Thank you, Ambassador. The floor is yours, Ambassador.
Yes.
Thank you, Julio. Thank you.
شكرا خوليو، شكرا لجميع المشاركين على هذه المبادرة.
First time an online workshop, labor rights of foreign workers in Qatar. Let me tell you first that this initiative has been very well received in Mexico City, and the Foreign Ministry has considered this initiative as an emblematic one, which of course is paving the way for similar activities in other Mexican diplomatic and consular representations around the world. I also want to welcome all participants from the resident Mexican community in Qatar who live and work and who are today with us. As you may know, you may be very well aware, this workshop is a joint effort developed by the Embassy of Mexico in strong and close collaboration with the project office in Qatar of the International Labour Organization, to whom we are deeply, deeply grateful. I would also like to express my deepest gratitude to our good friends from the Ministry of Labor of the State of Qatar, because their participation is an example of the great collaboration between the governments of Mexico and Qatar, and shows signs of the renewed and strengthened state of our bilateral relations. I also want to express my sincere gratitude to Al-Saidi law firm, which has been a fundamental ally in advising our Mexican community in order to safeguard their rights and to make known their obligations while residing and working in Qatar. As many of you know, the Mexican community in Qatar is very dynamic and composed by 650 persons approximately. Most of them are fully integrated as employees in different Qatari companies in sectors such as air industry, hospitality and tourism, energy, and even in the public and private education institutes. In this context, I don't want to abuse of the floor. I invite my fellow Mexicans and I encourage them to take today's opportunity to learn more about their rights, obligation, and available resources according to the labor law of Qatar. Again, thank you very much for the support of the participant institutions. Thank you very much to all of you who are participating in this online workshop. And Julio, thank you for the effort that you deployed in order to make this initiative a reality. Once again, I give the floor to Julio. Thank you again.
Ambassador, for your kind words. So we'll give the floor now to His Excellency Max Tuñón, who is the head of project office in Qatar of International Labour Organization and one of our closest allies of this diplomatic mission. Mr. Tuñón.
Thank you very much, Julio. Thank you very much, Ambassador, also for those welcoming remarks. I think it very much sets the scene for a productive, interactive discussion with the Mexican community here in Qatar. We're really appreciative of this collaboration with the embassy as well as the Ministry of Labor. We've been working for many years with the Ministry of Labor on advancing the government's labor rights agenda, and indeed we've seen tremendous progress in that short period of time. But we also know that there is still a need to communicate those changes with workers in different sectors of different nationalities, in different languages, etc. That's one of the benefits, the beauties of working in Qatar, is the dynamic labor market. It comes from all over the world, but also it makes a bit of a challenge to communicate across these nationality groups. But we have this wonderful opportunity here today to do so for the first time with the Mexican community. The situation in Qatar is always changing. I mean, as I said, there's been a lot of legislative changes in the past few years, as well as procedural changes. And in the last year, in 2023, also, we saw a lot of changes to the nature of the services that the government is providing to workers. A lot of these services have moved online and in order to increase efficiency of them. So you'll see, and I'm sure the colleagues from the Ministry of Labor will present the various electronic services that are available to workers with the view of increasing efficiency. And I think that's really a tremendous step forward, and in many ways is quite groundbreaking in terms of reaching out to workers of different nationalities and in different languages. As I said, the changes that have been introduced in recent years are very positive. We can see that Qatar is on a very positive trajectory when it comes to its labor rights agenda. But at the same time, introducing these changes to make sure that they benefit all workers and indeed all employers is a process that will take time. And building the institutions that come from this legislation is also a process that will take time. We look forward to soon finalizing a new 4-year program of cooperation with the government of Qatar that will support the objectives in the broader national development strategy and ensure that these aims will also, the aims of the labor reform agenda will also bring forward the objectives of that national development strategy, particularly when it talks about preparing a future-ready workforce. So I also don't want to speak too long. We've got the excellent number of speakers who will be presenting on the labor law, the procedures, and able to answer questions. So thank you very much again to the Ministry of Labor, to the Ambassador and the Embassy of Mexico.
Thank you very much, Excellency. As our head of mission already well said, the support of the International Labor Organization is the most valuable for the work that the Embassy of Mexico is doing here in Qatar in order to inform the Mexican community about their rights and obligations, and whenever they have a need for assistance and information, we have always had the kind assistance of our good friends of the ILO. So thank you very much, Mr. Tuñón. So so now we go to the main part of this workshop. We will have the presentations of first Mr. Abdulaziz Al-Ahmi from the Labor Relations Department of the Ministry of Labor, and after that, Ms. Njud Al-Mutawa from Labor Disputes Department. If the participations are in Arabic, for those English-speaking persons, we can click in the interpretation button at the bottom of the screen, and we can choose the option English, where we will have the English translation in real time. So, Mr. Abdulaziz Al-Ahmi, the floor is yours, sir. Thank you very much for participating today with us.
Thank you. Assalamu alaikum. I'm here from Ministry of Labor of إدارة علاقات العمل. So I speak in Arabic, yes? Okay. إدارة علاقات العمل تختص إدارة علاقات العمل على تصديق عقود العمل والشهادات والمستندات.
The Labor Relations Department is in charge of approving employment contracts and raising awareness about obligations and rights for workers and employers. It was mentioned earlier that many services of the ministry were improved and automated. We have many electronic services available today. As I said, this department is in charge of approving and authenticating employment contracts and other relevant documents. The workers can access the website of the ministry to complete this process. All the information is provided online, and it's authenticated also electronically by our staff. Is this brief clear so far?
Okay. Also بعد عندنا تغيير جهة عمل دراسة طلبات تغيير جهة عمل
We
جميعها.
are also in charge of changing employers, secondment. For instance, workers can submit a request to change their employers online.
تم الموافقة عليه أيضا
The same applies for secondment, and
يحضر إلى الوزارة يكون التقديم إلكتروني.
there is no need for the workers to visit the premises of the ministry to complete any of these processes. Workers and employees can also change their occupation or even their job title. Of course, this is based on their on the achievements or on their degrees and diplomas. If they wish, they can do so after submitting the required documents.
يتم طبعا تنسيق مع في الإدارة بخصوص انه يسوون او عمل انتخابات تنظيمية بخصوص انه مع الإدارة عندنا في إدارة علاقات العمل قسم التوعية.
Are also in charge of raising awareness among workers and in charge of joint committees and elections and the different bilateral agreements that can occur between what we call joint labor agreements between companies and the ministry. We also oversee, as I said, the elections of the joint committees together with other relevant departments in the ministry. Within the department, we have different units. We have a unit that is in charge, for example, of the authentication of employment contracts, one in charge of raising awareness about labor law and other relevant laws and regulations.
طبعا عندنا اقسام الاداره واختصاصها التصديق الرقمي لعقود العمل متعدد اللغات جميع اللغات متوفره.
We have the electronic contact authentication service in different languages. I think you may be aware of this, but since the main language is Arabic, the main contract will have to be, or the main authentic version is in Arabic, and we also provide translations into other languages.
ايضا خدمه ترخيص عمل اعاره كلي او جزئي في حال مثلا اذا العامل.
We also have full or partial secondment services. Say, for instance, a worker is currently employed by a specific employer and they wish to work for a different employer for a short period of time, say 6 months. They can also apply for this service and it will be authenticated by our staff electronically. We can also provide certificates for workers if need be. These certificates can also be requested online. We do provide information about the different companies, including number of workers, sector, activities, etc. And as I said, finally, we have a service whereby workers can request to change their employers online. The awareness unit is in charge of raising awareness about the labor law and other relevant legislation. They also provide advice regarding any of the provisions of the labor law or other relevant legislation. Workers can submit their requests or their questions, and our staff will respond to them. We have
المنشآت بحيث انه في يعني صار في تواصل مع
We also have a periodic follow-up
يطورون من العامل او يطورون من المنشأة.
between the ministry, employers, and workers to improve our services and also to promote the relationship between workers and employers.
Yes.
Sorry to interrupt you, sir. If you have a presentation, you can now share the screen so you can show the presentation.
Actually, I don't have it now because already they tell me they
Oh.
will send it for you.
Oh, understood. Okay.
I can send it by email if you want now.
Perfect, sir. Thank you very much.
Okay. Just a minute. Can you send for me your email?
Excuse me, we have both presentations here. Would you like, I don't know, maybe I could try sharing them from here?
Wait, just a minute. Which one? Yes, this is for. Can you show me it?
1 minute.
Yeah, it's okay.
Yes, I will. Labor Relations Department. One second,
Yes.
please.
Perfect. Thank you, Michael.
Let me see, sir. I'm not sure if I have share screen. Yes, 1 minute. Can you see the
Yeah, it
PowerPoint?
is, but but it is in English, so you can go down, I think. Yes. No, go back. One more, I think. Department.
This is it.
Yeah, it's it, but it is in English. So I think I am in slide number. If you want to read it again, I can. If you want me to continue.
No, I guess you can continue. Yes.
Okay, so it is in slide number 2, 3, 4, 5, and 6. No,
Here we are.
slide 6.
You just let me know when you want to change the slide. That way.
Yeah, it's okay. Thank you. Okay. So I will repeat again that this slide. احنا في اقسام اداره اختصاص اداره قسم التوعيه والارشاد والتنظيمات.
As mentioned, we have the awareness unit that works on raising awareness for workers and provide guidelines and also provide handouts for workers to respond to some questions. We also provide advice and information on the application of the labor law and relevant companies and follow up on the work of joint committees and joint negotiation and agreements between workers and employers. Workers and employers together with the ministry can follow up or can even mandate a group to liaise with the ministry on matters related to awareness raising. And finally, we respond to
استفسارات متعلقة من ناحية
related to the application of the labor law and other relevant legislation, be it from workers or employers. Our staff are ready to respond to these inquiries. We move to the next slide.
آخر شيء هني الخدمات اللي تقدمها إدارة علاقات العمل بشكل عام خدمة طلب تغيير
The
جهة عمل إنهاء علاقة
Labor
عمل
Relations Department can
مغادرة
also
الوطن
provide the service of
خدمة
canceling
استخدام
requests to
قرارات
change
إلكترونية
employer,
خدمة إلغاء طلبات تغيير جهة العمل من قبل العامل إنه يستطيع العامل أيضا إذا كان عنده
withdrawing
طلبات
also
إلكترونية
the request to
للانضمام
change
أو
employers
التعديل
or
من
changing employers.
صاحب العمل إنه
So
يقدم
3 options: changing employers,
يقدم طلب
canceling the request, and withdrawing the request. All this can be made can be done electronically. We also have the multilingual digital contract authentication, the service of printing out the contract once the contract is issued, because workers should keep a copy of their contracts. We also provide awareness and guidance for companies, for both workers and employers. We provide statistics and data information, including on the number of workers in one enterprise. And finally, requesting partial or full secondment request outside of their working hours. This request can be submitted online.
طبعا بموافقة بالفترة مثلا 3 شهور أو 6 شهور بعد
for 3 months or 6 months outside of the working hours with the current enterprise. And finally, as mentioned before, workers can also amend or change their profession or job title.
next slide please.
Next slide, please.
Do you hear me? But I cannot. اوكي. ايضا خدمات اداره علاقات العمل، خدمه تصديق العقود الالكترونيه. هذه
We
الخدمه
also So the electronic contract authentication service is a service that allow changing employers by mutual consent, changing employers for specific contract, and also for contracts and arbitrary dismissal. We also have the complaints unit whereby workers can also submit can complete all these processes without personally showing up to our offices. Finally, the secondment service allows workers to work for another employer without having to change their current employer. They will submit a request to work for a period that can go between 3 months to 6 months, and it has to be outside of current working hours. Next slide, please.
آخر خدمتين في إدارة علاقات العمل اللي هي خدمة اللوائح والجزاءات والشهادات. ستسمح هذه الخدمة للمنشأة استخدام خدمة الشهادات، استخدام خدمة اللوائح.
Finally, we provide certificates, statistics, and other documents available online. This service is available electronically and can be accessed without visiting our premises. The last service is related to the establishment of joint committees in order to promote the workers' voice and work on limiting and addressing conflicts in the workplace. And this is in line with our national strategy. It is crucial to listen to the workers to learn whether they are facing challenges or problems with their employers. We also respond to any queries that they might have regarding the labor law and its application. This is, in summary, the role of the Labor Relations Department at the Ministry of Labor. Thank you.
This is all the thing about the department, and thank you. listening. And sorry, maybe I'll take a long time.
Thank you, Mr. Abdulaziz. Thank you very much for this presentation. Now we give the floor to Ms. Enjud Al-Mutawa, also official from the Labor Disputes Department of the Ministry of Labor. Ms. Al-Mutawa, the floor is yours, madam.
Hello, my name is Enjud from Labor Dispute Department. I'm glad that I'm talking to you today. I will explain to you today about the electric service provided by Labor Dispute Department. We have a complaint and a report platform. The second service we have an electric calculating the ending service and follow up the complaints. Targeted group of the complaint and report platform, the worker who subject to the provision of the labor law number 14 of 2004, and worker subject to the provision of the domestic worker law number 15 of 2017. I will give you quickly information about the platform. The user manual contain 11 language: Arabic, English, Urdu, Filipino, Hindi, French, Sinhala, Bengali, Tamil, Nepali, and Spanish. It will help the worker when they use the platform. The worker can submit the labor complaint inside or outside Qatar, provided that they are registered to the national documentation. But when he is outside Qatar, he needs to appoint someone on his behalf.
Sorry to interrupt, Michael. Do you have this presentation? We've currently got the wrong presentation on the screen.
Oh, yes. Yes, 1 second, please. I was labor disputes. Give me 1 second, please. Yes, yeah. I am sorry, but something is misbehaving here. 1 minute. Can you see the correct now?
Yes, yes.
Okay, yes.
It will be the fourth slide. Okay, so I will repeat it again. Quickly information about the platform. The first information is the user manual contain 11 language: Arabic, English, Urdu, Filipino, Hindi, French, Sinhala, Bengali, Tamil, Nepali, and Spanish. It will help the worker when they use the platform. And the second information, the worker can submit a labor complaint inside or outside Qatar. They are, provided they are registered to the national documentation. When he is outside Qatar, he need to appoint someone on his behalf. And the third information, the worker can go and follow up the case on 4 branch: Al-Wakra, Industrial Area, Al-Shahaniya, and Al-Dafna. Also, he can follow up, document, and review the complaint file after we transfer the complaint to the dispute resolution committee. Next slide, please. And now we will talk about the objective of the platform. The first objective is to protecting the right of the migrant worker to ensure their right, reducing the period of resolving the complaint, and is to submitting and following up the complaints. Next slide, please. The worker can file a complaint in this following cases: delayed wages, vacation allowance, ending service, air ticket allowance, and other requests like a compensation, for example. Next slide, please. And how to submit and follow the complaint. The worker, he can find this link in Ministry of Labor website. I hope that our services are clear for you. If you require more information, please let us know. Thank you.
Thank you, Madam. Thank you, dear colleagues from the Ministry of Labor. Now we will give the floor to Mr. Mikhail Kandarakis, technical specialist from the International Labor Organization Project Office here in Qatar. Mr. Kandarakis, the floor is yours now.
Thank you very much, Julio, and thank you and the ambassador for organizing this this meeting, this event, this seminar, this workshop. I believe that most of all major services that the Ministry of Labor is offering to the workers, to the migrant workers in Qatar, has already been mentioned. So what I would like to do is mostly summarize the major changes in the labor legislation that have happened in Qatar in the last years through the collaboration of the Ministry of Labor with the International Labor Organization. I would like to add also some more comments about the labor market, let's say the labor realities in the country of Qatar as we speak. And then, of course, we will continue with the presentation and the remarks of my colleague from the law firm, and we will open the floor for questions. So the whole purpose of the work that the Ministry of Labor is doing in collaboration with the International Labor Organization in Qatar has always been to make some processes and make the life, let's say, of workers in Qatar easier by offering the services that they are offering. But in order for this to happen, there had to be there was a core of reforms, of legal reforms that had to be adopted by the state of Qatar. And again, in summary, those reforms mostly included, first of all, the removal of the need for an exit permit from the employer in order for workers to leave the state of Qatar. As things are right now, workers can apply to the Ministry of Labor, and this is an official process that is handled by the Ministry of Labor if they want to leave the country legally. A second major reform was the removal of the no objection certificate for workers to be able to change employers. So in the previous situation, when a worker wanted to change employment, this could only be done if they had the specific and written approval of their current employer, while now this obligation has been removed from the Qatari labor law. So there's no need for no objection certificates anymore. Of course, the two previous presentations have analyzed more or less what are the processes for employment change and complaints filing when someone has a labor complaint in the state of Qatar right now. I would like to say that the employment change platform has not only facilitated employment change applications for all workers because of the use of the electronic platform and their ability for workers to apply for employment change even through their mobile phones or through any computer, any public or personal computer. Also, the same has happened with the filing of any labor complaints. Whenever any worker has any kind of dispute with their employer, they can equally easily file a labor complaint through the electronic platforms of the Ministry of Labor. While, needless to say, the previous process entailed only them appearing in person, the workers appearing in person in some of the offices of the Ministry of Labor and having to go through the whole process of queuing together with hundreds or even in some cases thousands of other workers that had similar issues. Another big reform that was adopted in the recent years has been the creation of the dispute settlement committees. The dispute settlement committees are specialized labor courts that only handle labor disputes. So it makes the process of litigating labor-related dispute a lot faster or a lot easier for the worker and much more simplified, let's say, than having to go through the different other aspects of the labor of the Qatar labor court system. The dispute settlement committees initially were 3 when they were created a few years ago. Now they are 5, and I am sure that there is talk among the state of Qatar authorities to create even more, to facilitate even more and speed up even more the processes. Now, we have seen that these reforms and these changes in the labor legislation and the labor realities in the state of Qatar have already been informed to many of the workers in Qatar, and most of the workers from our experience every day already understand these changes and the processes. But nevertheless, the awareness raising that we are providing today and the assistance to workers, to migrant workers in the state of Qatar is something that cannot stop. It's an ongoing process. And it is an ongoing process not only because the Ministry of Labor is perpetually, let's say, changing and making processes even easier and even more efficient, but also because the population of workers and the consistency of workers in the state of Qatar is always evolving. Qatar is a place of receptance of many workers from many different countries. And in that sense, the population of the migrant workers in the country keeps changing. So there is always the need to inform, to share this legislation and the changes in the legislation with as many workers as we can. So this is more or less what I wanted to do. Maybe it would make sense to very quickly, again, also summarize the processes of employment change and the process of labor complaints by the Qatari labor law. So when a worker needs to change employment in Qatar, the first thing that they have to do is to, of course, come in contact with their current employer and submit a resignation to their current employer. Submit a resignation that can have a verifiable date of submission. After this document has been submitted or has been sent by mail to the employer, they need to apply for employment change through the electronic platform of the Ministry of Labor. When the Ministry of Labor receives the application for employment change, the worker is receiving a text message in their phone that says that the employment change application has been filed and is under review. In this case, the worker needs to wait for the approval of the employment change application by the Ministry of Labor. I have to clarify here because I've seen from experience that some workers are confused with that. that the employment change process has to be initiated by the worker, and it has to go through the electronic platforms of the Ministry of Labor. It is not a process that is done anymore through communication only with the current employer of the worker. Now, once the employment change application is approved, the worker will receive another message that is specifying what is the notice period. The notice period is the period that the worker has to continue working with their current employer until they are free to leave and move to the new employer. This notice period is usually 1 month for employment up to 2 years and 2 months for employment with the same employer for more than 2 years. It is also important to note here that sometimes the message for the approval of the employment change and the message for the specification of the notice period might come somewhere in the middle of the notice period. So workers, it's my advice that workers should be patient and wait for the message to come and not leave work before that notice period is specified and expires, of course. Another misconception that I have found from experience that can happen among workers is that they believe that it is the agreement between them and the current employer that specifies the notice period. This is not correct. The notice period is specified officially only by the Ministry of Labor. So once the worker receives the second message that says that the notice period is up until a specific date, they have to work until a specific date, and then they are free to pass over to a new employer. Also keep in mind that the new employer has approximately 1 month, whereas they have to submit electronically the new contract to the Ministry of Labor for approval. And this is what essentially terminates the hiring process. It is not just signing the labor contract between the worker and the new employer. Now, regarding the labor complaints process, the beginning is the same. The worker has to file a complaint electronically through the web page that you see in front of you on the screen. I actually left it on the screen for the people from Facebook Live to have the link in front of them. So when you access this page, you enter with your mobile phone number and your QID, and then you are presented with a list of different types of labor disputes that can happen between a worker and their employer. So the worker must choose what are the grievances that they have against their current employer, and also they have the possibility through the system to upload documents that support their case, that prove, at least in their opinion, their case. Once the complaint is submitted, the same way as with employment change, they will receive a message that the complaint has been submitted, and in few days they will also be called at the Ministry of Labor for what we call the conciliation process. The conciliation process is when the Ministry of Labor, the officers of the Ministry of Labor, specific officers of the Ministry of Labor, they call both parties, they call the worker and a representative of the employer or the employer himself or herself, they call them for a meeting in front of this Ministry of Labor officer to try and find an amicable solution, to try and negotiate a solution that would save both of the parties time and will keep the case from going to the labor courts. This meeting, the conciliation meeting, can happen once, twice, in rare cases, even a third time, in order to find an amicable solution. But if this is not achieved, then the case is automatically transferred to the dispute settlement committees. As we said, the dispute settlement committees being the labor courts that are operating in the state of Qatar. So after this process is done, The rest of the communications is coming now from the dispute settlement committees that are under the Ministry of Justice and not anymore under the Ministry of Labor. So the worker must wait until they have their hearing date, the date that they will appear before the court, and they will bring all the supporting documents in print and appear before the judge, the labor judge, and present their cases. So, of course, with the participation of the employer at the same time. After the hearing date comes and is over, then, of course, they have to wait for a court decision. The court decision in itself has to go to what is called the enforcement court. So most of the cases that we see here in Qatar regard payment of wages or payment of other allowances. So just having the paper of the court decision, the worker cannot receive their money. They have to go through the enforcement court, submit the court decision to the enforcement court, and then the enforcement court takes all the actions that are needed for the worker to be satisfied in their financial grievances. Now, if this doesn't happen, the last resort that there is here in Qatar is what is called the Worker Support and Insurance Fund. We call it usually the fund for shortness. So this is the last resort that a worker with a final court decision has in order to be able to get their dues from the employer. The Worker Support and Insurance Fund is mostly used against companies that are either insolvent or in very serious financial distress, so they are objectively unable to provide the financial satisfaction as per the court case. I believe that this is more or less the processes, the two main processes for employment change and complaints. So I would leave it there. I will also say that here at the ILO, here at the office, we provide free legal advice, not assistance. We are not involved in cases directly, but we provide free legal advice to any worker that needs this free legal advice. They can contact us. But of course, if they need actual legal assistance, they would have to retain the services of my dear colleague that is coming after me. So I will leave it there. Thank you very much, and I'm looking forward to the questions and answer part. Thank you.
Mr. Kandarakis, thank you very much for this very, very didactic presentation. So our next speaker is attorney Fatima Al-Saidi, who is CEO and founder of Al-Saidi law firm. And as we already said at the beginning of the workshop, one of our closest allies when any member of the Mexican community needs legal assistance, legal orientation, and sometimes even legal representation. So, Madam Al-Saidi, the floor is yours.
Yeah. بداية تسمح لي بس can you just make for me the sharing so I can share the presentation?
Yes, madam.
Yes, I have stopped sharing to leave the floor for another screen sharing, yes.
I still cannot share it. Yeah.
Madam, now you are co-host. Oh,
Stay a moment. السلام عليكم ورحمة الله وبركاته. بداية أود أن أشكر سعادة السفير والقائمين على
I would like
تنظيم
to
هذه
begin by
الورشة
sending my thanks to His Excellency the Ambassador and
وتشرفت
the
بحضوري
Embassy
مع المتحدثين
of
جميعهم
Mexico.
وأشكر جميع الحضور أيضا.
I am extremely pleased and
راح
honored
أتكلم إن شاء الله.
to take part in this workshop. I am sorry, but Mrs. Fatima has a lot of background noise.
أنا لأني بس أسمع الترجمة أستاذة، فلذلك خلينا نجرب إن إحنا. صوتي مسموع؟ صوت مسموع؟
صحيح أستاذة، تفضلي.
صوت مسموع؟
Yes, it is. Please go ahead. Yeah. Today, I will be talking about the rights and obligations of employers and workers according to the labor law. I will be addressing the employment contract, the rights and obligations of workers and employers, ending the employment contract, and complaints and conflicts. The Labor Law number 14 of 2004 has outlined the rights and obligations of both workers and employers. It has a number of provisions and regulations that depict the roles and responsibilities of employers, workers, and joint committees. I will be talking about the employment contract. It is an agreement between an employer and the worker. It could be definite or indefinite in time, and in which the worker admits to be working on a task as requested by the employer. Of course, there are some formalities that employment contracts have to meet, and these include, first, it has to be written, authenticated by the Labor Department, issued in two versions, in Arabic and one other language. It stipulates the relationship between employers and workers, including the tasks, as well as the name of the worker and employer, the name of the worker, their education level, their nationality and their occupation, their address, and any identity document. The start date of the contract, the end date of the contract, if any, the nature and type of work, as well as contract work. If the contract is not written, the worker can prove this employment relationship using any kind of evidence. The law outlined the roles and responsibilities, as well as rights and obligations of workers and employers. What does the worker have to do? First, to be able to take up the tasks by himself, and to respond to the requests of the employer in the execution of the work, as long as it is not contradictory to what is stipulated in the employment contract, and as long as it does not put him in or her in danger, not to work for any other employer or without payment, not to use work-related materials outside of work, not accepting grants or presents because or for making the tasks, and not to reveal any of the business details to others. In addition, in parallel, the employer has other obligations, including but not limited to payment of salary. For example, the employer has to exert all efforts to allow workers to execute their work and provide all the requirements needed for that. And if the worker is ready to do the work, but these conditions were not met, then in this case, they have the right to receive the same benefits as if they did the tasks. And employers can also ask workers to execute other tasks as long as it does not cause any harm to the worker, as long as it is not very far from what the main task of the worker is. One of the articles of the labor law of 2004 we have worked on several cases related to this article. It stipulates, for instance, that any employment contract is considered null if it includes any claim from the worker to work for a lifetime with the same employer, or to stop from working in any occupation for the rest of his life after leaving work. This is an absurd thing, and this is why it is null. Of course, when we talk about non-compete clauses, the labor law has specified the non-compete period for 1 year. Employers may include a clause in the employment contract requesting employers not to work for a competitor for a maximum time of 1 year. Concerning ending the employment contract, of course, both parties may end the contract after the probation period, or even without observing the notice period if it is not included in the employment contract, without providing any justifications. This law was amended, and the International Labour Organization provided us with the different notice periods to end a contract. And I will be able to share this with you. So after during the first 2 years, the notification period is of 1 month, and after the second year, the notification period is 2 months. Employers have also to pay the salary of the worker for the whole period of the notification, as stipulated in the relevant article, if the worker continued to work during this period of time. However, if the worker does not show up to work, the employer has to prove this to the relevant authorities. The worker also has a right to put an end to the employment contract before its expiry, if it's definite, and without or definite or indefinite, and the following cases: if the employer fails to observe their obligations according to this employment contract, if there was any violation or attempt to attack the worker, be it physical or otherwise, towards the worker or one of their family members. As well as when there is an imminent danger that is threatening the safety of the worker or their health, as long as and the employer has not tried to stop or to address this threat. And in other cases, the notification period has to be 15 days, while providing the justifications for the Ministry of Labor. Moreover, the employer, when ending the employment contract, should do the following: to provide the worker with a service certificate indicating the first day of work or date of beginning and ending dates of work, and the nature of work that the worker was doing. Now, moving to conflicts. If a conflict arises between employers and workers, there is a dispute settlement committee established at the Ministry of Labor. It is chaired by a judge and a number of members who are experienced, and they the minister, the Council of Ministers has issued a ministerial decision on the roles and the responsibilities of these dispute settlement committees and their rules and regulations in coordination with the Supreme Judicial Court. These dispute settlement committees are in charge of adjudicating in cases related to individual complaints, and the final decision should be taken within 3 months from the first hearing, and the members of this dispute settlement committees should be independent. Now, concerning the process of submitting a complaint, as mentioned today, submitting complaints can take place online. When a conflict arises related to the application of the labor law, they have first to attempt to find an amicable solution by seeking the support of the Labor Relations Department or Human Resources Department at the Ministry of Labor. And the concerned department should take the necessary measures within 7 days to find an amicable solution. However, if no solution is reached, or if one of the parties refused the proposed solution, the concerned department has to transfer the case within 3 days to the Dispute Settlement Committee. Afterwards, the Dispute Settlement Committee will have to adjudicate in the case. I would like to highlight one key point. All the cases that are submitted by complaints are usually addressed swiftly and are not subject to what we call judicial fees. However, in line with Article 113 of the labor law, the case cannot be submitted after 1 year of the end of the employment relationship. Thank you so much.
Thank you, Madam Al-Saidi. Thank you very much for your presentation. We are going to translate the presentation into English and Spanish in the upcoming days, and we will upload this information in our website, in our Facebook webpage, and in the website of the embassy. So thank you very much, Madam. So I will give the floor to my colleague Paulino Robles Gil, who is going to read a couple of questions that we have received from our Mexican community regarding some very, very specific issues, no, that they have either faced or known in their workspace. So thank you, Paulino.
Thank you very much, Consul Julio. So one of the things that they have written us on social media during these presentations is regarding the exit permits. So some of them, even though these exit permits requests supposedly is no longer necessary, many of our connationals, they still face the impossibility to take the vacations or the days off in the days they promised or they're supposed to have them. And there are many reasons, or they are sometimes conditioned in order to get the exit permits. The second thing is that it seems not to be very clear or regulated in some job places or workplaces, the issue of extended labor hours. So for some of them, it is not clarified from when to when they have to work, if the commuting time is considered part of this, how is the process of paying extra hours, so the extended time. So for some of them, they are working over 12, sometimes even 14 hours, and the employer has not necessarily take action or compensate this. The other thing that I'm reading here is related to the conditions of the accommodation. Sometimes, especially people that come from abroad, they are told that the accommodation has certain facilities and the premises are in certain conditions, or that they have some appliances, but when they face the reality, the accommodations are not as they were promised or informed. But now they are already here in Qatar and they have a lot of room to navigate these conditions. So this is the kind of question so far.
Thank you very much, Paulino. Thank you very much. So if Madam Al-Saidi or our colleagues of the Ministry of Labor, even Mr. Michael, can guide us through these situations.
راح أتكلم بالنسبة لساعات العمل.
I will be speaking concerning the working hours. These are defined by the labor law. They are 8 working hours, 48 hours per week. Any additional working hours, these are considered overtime. And they should be paid an extra.
If I may add to that, there is an upper limit of 12 hours normally for work. I mean, of course, including the overtime that has to be paid. And there is also an obligation for at least 1 full day of rest during the week. And those, of course, are the minimum limits of the law. There might be an agreement in the labor contracts between worker and employer that specify more than that, more rest, I mean, or higher pay for the overtime work. But the minimum limits are specified, as we both said, in the law. The same goes for the exit permit. It is a little bit complicated. I or Madame Saidi, Al-Saidi, we could send you the articles of the law that specify the leave days that need to be, again, that are minimum for any labor relation, because they are very clearly specified in the law, and this has to be respected. All of this has to be respected, and of course, all of this, any violation of all of this gives ground to a labor complaint, as we both explained it before. So the worker, they can, if they go into the web page and they see the drop-down list of the specific complaints that they can raise against their employer, they will find the certain violations around working hours and overtime and pay. Now, about the conditions in the accommodations, because this is also in my area of work, I'm responsible for occupational safety and health at the workplace and the accommodations, of course. So the law, again, has a minimum specification of requirements of space and facilities that need to be provided by the employer to the worker as part of this agreement. And of course, the accommodation standards have to be up to minimum standards of humane living for any living human being. And on top of that, the fact that some workers receive false information about the conditions of accommodation before they come to Qatar, this by itself is also a violation that they can base a labor complaint onto. So if they are promised, for example, a room where they will be sharing with one more person and they are with 6, this by itself is grounds for a labor complaint. For extreme cases where they might not have hygiene facilities, or they might not be in working condition or anything like that, they can contact the Ministry of Labor, the labor inspection, especially the occupational safety and health inspection, and even anonymously file a complaint there that will lead to an inspection of the accommodation, and the labor inspectors there will take the legal measures against either the management of the accommodation or the company itself, whomever is managing the space there.
Perfect. Well, thank you very much, Madam Al-Saidi. So we are in the final part of the workshop. So I will give the floor to His Excellency Guillermo Dorica for the closing remarks of this this first online workshop that we hope it's going to be the first of many others that we will be having through 2024. Ambassador, the floor is yours, sir.
Thank you very much, Julio, and thank you very much to all the participants for their bright presentation of ideas and resources available in Qatar for the Mexican community that resides and works in this beautiful country of the Middle East. Let me say that Mexico is well known worldwide because of the special and very important attention that gives to our national diaspora all around the world. Our programs are very original. Our programs are always devoted to take care of the needs of the people and the families of this Mexican diaspora, and of course to protect them and to empower them wherever is possible. I'm certain that this online workshop contributes clearly to this goal and is establishing a precedent that has already been noted in Mexico City and hopefully will be replicated in the future in other Mexican representations. Again, thank you very much to all the participants. Thank you very much to the Office of ILO. Thank you very much to the Al-Saidi law firm. And of course, thank you very much to the authorities of the Ministry of Labor of Qatar, which have proved to be, as always, good friends and good partners to the embassy and to the people and the government of Mexico.
Thank you, Excellency. Thank you, all our colleagues from International Labour Organization, from Al-Saidi law firm, and from the Ministry of Labor, of course. Thank you for all the participants that could attend this workshop. And also on behalf of our ambassador, I would also like to thank our esteemed colleagues of the embassy. This was a joint effort of all the officials and staff of the Embassy of Mexico. We will try to do more and more online workshops, in-person workshops, and in-person and virtual briefings regarding many other issues, many other items that are of interest for the Mexican community in Qatar. So we will close the workshop, and once again, thank you all. Shukran.
Muchas gracias.
Thank you very much.
Thank you to all. Feel free to disconnect. Thank you.